So imagine for a second that you're showing up to a casino, you bring your own, hard-earned cash, you walk right up to the cage and you exchange it all for a big stack of chips.
Right.
And you just spend the whole night playing the tables, having a good time. But then at the end of the night, as you're cashing out, casino security just stops you. And they hand you a lawsuit. They are literally suing you for borrowing their chips.
Mm-hmm.
And they're demanding you pay them back for those chips plus interest. Oh, and they are keeping your original cash.
I mean, it sounds completely absurd when you frame it like that. It's just a total inversion of reality. You probably laugh them out of the building, right? Or call the police because the casino risked absolutely nothing. They took your asset and now they're claiming, that you owe them for the privilege.
Exactly. But what if, and stay with me here, what if that is exactly how your mortgage works?
Yeah, that's the big question.
Because we are jumping right into the source material today. Welcome to our deep dive. We are looking at this deeply fascinating, highly controversial curriculum. It covers common law and property defense. And today we're specifically analyzing lectures 1201 through 1207. And we're going to explore this idea that the entire real estate finance industry might just be operating on this, foundation of completely unprovable paperwork and a fundamental misunderstanding of who actually owes what to whom.
Right. It's a huge topic.
It really is. We're going to unpack the hidden mechanics of mortgages, the true nature of foreclosures, and how an individual can supposedly, fight back against these massive banking institutions by just completely flipping the script.
It's definitely a radical departure from standard legal thought, I'll say that. I mean, this curriculum completely deconstructs the conventional understanding of banking and debt and property rights. And, regardless of whether you ever actually face a foreclosure yourself or whether you even agree with this legal philosophy being presented, understanding the anatomy of these arguments is incredibly valuable for you as a listener.
Oh, absolutely.
Because it provides this massive high-resolution window into the vulnerabilities, the blind spots, and just the sheer bureaucratic chaos of modern financial institutions. We're looking at a system that operates almost entirely on absolute presumption. And these theories, well, they're specifically engineered to attack that presumption at its very root.
Right. And to understand how you even begin to attack a massive bank, I think we need to look at a real-world application of these theories first. The lectures open with this case study of a man named William Sarton. And his story, it really kind of lays out the foundational blueprint for this entire strategy.
Yeah, the Sarton case is the perfect entry point. It begins with a very common scenario, especially during times of economic distress. Sarton basically had a friend who was on the brink of losing a property to foreclosure. And to implement this defensive strategy, the friend transferred the property to Sarton via a grant deed.
Wait, let me stop you there, because that seems like a massive first step to me. Why transfer the property? Why couldn't the friend just fight the bank themselves?
Well, the friend absolutely could have. But transferring it to Sarton via a grant deed, it accomplished something crucial from a legal strategy perspective. It put the title of the property directly into Sarton's name. And in the eyes of the law, that gave him legal standing.
Oh, right, standing.
Right, you can't just sue a bank over a property dispute if you don't have a legally recognized interest in that property. So by holding the grant deed, Sarton now had skin in the game. When the bank made its move to take the property, Sarton had the absolute right to stand up in court and, defend it in his own name.
And the bank definitely made its move. The institution in this specific case, U.S. Bank National Association, they initiated a non-judicial foreclosure. And just for clarity, because this happened in California, they didn't have to go through some massive court proceeding first to take the property, right?
Yeah, that's a really important distinction. The United States is roughly divided into judicial and non-judicial foreclosure states. So in a non-judicial state like California, the deed of trust that a borrower signs typically contains this thing called a power of sale clause.
Power of sale, right.
And this clause effectively says that if the borrower defaults on the loan, the lender has the pre-authorized power to sell the property to recoup their money. They don't need a judge to sign off on a formal lawsuit first. The bank basically just follows a statutory notification process, and then they auction the house.
Right. So U.S. Bank triggers this non-judicial foreclosure. They just assume they've taken the property back, and then they pursue something called an unlawful detainer in the Superior Court of Orange County.
Yeah, and an unlawful detainer is basically just the legal mechanism for eviction. The bank is essentially telling the court, we now own this property. This person, William Sarton, is living here unlawfully, and we need the court's authority, usually via the sheriff, to physically remove him from the premises.
Now, here's where Sarton does something completely counterintuitive. because he had been studying these common law principles for years, right? He even paid for a comprehensive securitization audit on the property. And my understanding is that an audit like that, it digs through the entire history of the mortgage, finding every little irregularity in how the title had been, bounced around between different banks and Wall Street trusts. He had this massive binder of evidence showing the bank's paperwork was a total mess. But he doesn't even use it in his lawsuit.
And he doesn't touch it at all. And his reasoning there is just a masterclass in procedural strategy. Sarton operated on this self-described philosophy of laziness.
Laziness is a legal strategy. Yeah, I mean, I kind of love the sound of that, but how does that actually work when you're fighting a multi-billion-dollar bank?
It works by understanding the flow of energy in a courtroom. The whole goal of this lazy strategy is to do the absolute least amount of work yourself while placing the maximum evidentiary burden on the opposition. So to grasp why this is so effective, we really have to introduce a vital concept from the Uniform Commercial Code, or the UCC, specifically the concept of the holder in due course.
Okay, I've definitely heard that phrase tossed around in financial news. What exactly makes someone a holder in due course?
So the Uniform Commercial Code is this comprehensive set of laws governing all commercial transactions in the U.S. Under the UCC, a promissory note, which is the actual piece of paper you sign promising to pay back your mortgage, it's considered a negotiable instrument, much like a check. And a holder in due course is a very specific legal status. It is a person or a corporate entity who acquires that negotiable instrument for value in good faith and without notice of any defect or, previous dishonor.
And if you manage to achieve that status,
if you legally meet those criteria, you are granted immense power. You get the right to enforce payment on that note, free and clear of almost all competing claims or defenses that the borrower might, try to raise.
okay, so U.S. Bank walks into the Orange County court for this eviction, and they are operating on the absolute presumption that they are the holder in due course. They have the paperwork, they say Sarton defaulted, they assume they have the right to evict.
Precisely. And this is exactly where Sarton's laziness flips the script. Because the standard defense for a homeowner facing foreclosure is to try and prove a negative. The homeowner frantically tries to prove that the bank doesn't have the right to foreclose. They try to point out flaws, they bring up those audits you mentioned, they argue about missed payments. It is exhausting, it's really expensive, and it usually fails because the courts are just primed to favor the bank's administrative records. But Sarton, he simply stood his ground, folded his arms, and demanded the bank prove their affirmative claim.
He demanded they prove they were actually the holder in due course.
Exactly. He demanded they produce the original wet ink promissory note. And even more importantly, he demanded they prove a continuous, unbroken chain of assignment. From the original lender who funded the loan on day one, all the way down to U.S. Bank.
Okay, let me try out an analogy here to make sure I'm fully tracking the mechanics of this burden shift. So if I go to a big box electronics store and I buy a massive flat screen TV, I take it home, and it doesn't turn on. When I take it back to the customer service desk to demand a refund, the burden of proof is entirely on me, right? I have to produce the receipt to prove I bought it there on that specific day for that specific amount. The store doesn't have to prove anything until I show my paperwork.
Right, that's how it normally works.
So Sarton's essentially applying this to real estate. The bank is showing up to repossess his house, and he is just looking at them saying, show me the receipt. In fact, show me every single receipt you've ever had since the dawn of this loan, for every time this piece of paper changed hands between your corporate subsidiaries. Is it truly that simple to force the bank to show their work?
I mean, it is that simple in theory, but it is incredibly disruptive in practice. To understand why your TV receipt analogy is so potent there, you have to look at the reality of modern banking versus the reality of that big box store. If you buy a TV, the store has a centralized, highly accurate digital inventory system. They know exactly when that TV arrived on a truck, when it was scanned at the register, what credit card bought it.
Sure, it's all tracked.
But modern banking, particularly the mortgage industry in the early 2000s, it operated on massive volume, frantic speed, and a vast, frankly sloppy presumption of validity. They were processing thousands of foreclosures a week. They did not have a clerk lovingly curating a bespoke, perfect file for every single mortgage. Mortgages were being bundled, sold, split, and traded globally at just lightning speed. So by demanding strict evidentiary proof of the chain of title, by demanding that unbroken chain of receipts, Sarton's strategy exploits the bureaucratic chaos that the bank relies on. The bank is wholly unprepared for a borrower who doesn't argue about the missed payment, but instead challenges their fundamental legal standing to even ask the question.
And to force the judge to actually listen to this demand, rather than just, rubber stamping the eviction, Sarton utilized a specific legal maneuver. The lectures highlight his use of a declaratory judgment.
Yes, this is a critical tactical mechanism. A declaratory judgment is a binding judicial determination of legal rights or duties in a controversy. But the key to its power is that it is sought before a final injury or breach occurs.
Okay, so he isn't suing them for damages after they kicked him out?
No, not at all. By filing an action for a declaratory judgment, Sarton forced the court to hit the pause button. He's asking the judge to declare, legally, who is actually in the right regarding the disputed property before the eviction can be finalized. He's effectively saying to the court, before you allow this entity to use the sheriff to remove me from my home, compel them to prove they actually have the legal authority they claim to have. It forces the bank to produce the paper trail before the physical violence of an eviction can even proceed.
It's literally like pulling the emergency brake on a runaway train. You're just saying, stop everything. Before we argue about the destination, judge, make them prove they even own this train.
That's a great way to put it.
Which brings us to a massive realization. Because Sarton's demand for that paperwork trail, his demand for the receipts, it takes us directly into the dark heart of why the bank struggles so profoundly to produce it. We are stepping right behind the curtain of mortgage securitization, looking at the concepts detailed in lectures 1202 through 1205.
This is where the paper trail goes from being just murky to entirely opaque. And it's where the legal vulnerabilities of the banks become glaringly obvious. When the curriculum discusses the forensic audit, it's talking about a microscopic, forensic-level scrutiny of origination documents, recorded assignments, substitutions of trustees, and trustee deeds. And what these audits almost universally reveal is the chaotic, fragmented reality of securitization.
Securitization. I mean, it was the massive buzzword of the 2008 financial crisis.
Right.
Right? The thing everyone blamed for the housing crash. But the way these lectures break it down, it isn't just about economic risk, and it's about how the process fundamentally poisons the legal standing of the banks. Let's, walk through it. You go to a local bank, you sign a promissory note for a $500,000 house. You think the local bank holds that note in a vault, and you just pay them every month.
But that is almost never the reality. That promissory note is an asset, and the local lender almost immediately sells it. During the peak of securitization, these notes were bundled together by the thousands and sold off to massive Wall Street trusts. The lectures specifically mention entities like Lehman Brothers, and this was almost entirely done without any disclosure to you, the borrower.
And so my mortgage is now just a tiny fraction of a massive financial smoothie sitting in a trust in New York.
Exactly. And the legal implication of that blending process is profound, because the original local lender you signed the paperwork with, they often become merely a nominal entity.
Nominal meaning like in name only.
Yes, in name only. Their name might still be on the top of your monthly statement. They might still be the ones collecting your check every month, but they have no actual skin in the game anymore. They don't own the underlying debt. They have already been paid when they sold the loan to the trust. Therefore, they haven't suffered any actual financial loss if you suddenly start paying your mortgage.
Which means they shouldn't have standing to sue you. I mean, if I punch someone in the face, their neighbor can't sue me for the medical bills.
That is the exact common law principle at play here. You must suffer an injury in fact to have standing to seek redress in a court. But the banking industry had a massive logistical problem, because if millions of mortgages are being sold and traded between trusts on a daily basis, the traditional legal requirement was that every single time a mortgage changed hands, an assignment of the deed of trust had to be filed with the local county recorder's office, and a fee had to be paid.
And let me guess, banks hate paying fees.
Oh, they absolutely do. It was slow, it was expensive, and it was fundamentally incompatible with the high-speed trading of mortgage-backed securities. So the banking industry created a private workaround. They called it MERS.
MERS, the Mortgage Electronic Registration Systems. The lecture spent a lot of time dissecting MERS. What exactly is it, and why is it so legally vulnerable?
So MERS acts as a private electronic registry. It was designed to track servicing rights and ownership of mortgage loans entirely outside of the public county records. When a loan is originated, the bank registers it with MERS. The paperwork will often designate MERS as the nominee for the lender and its successors. The idea was that the mortgage could be sold 100 times on Wall Street, But as long as MERS remained the permanent nominee on the public record, no new county fees had to be paid and no new paperwork had to be filed locally.
It's just an administrative shell game to bypass local property laws. But the curriculum argues that MERS's legal foundation is incredibly shaky, right? The strategy asserts that MERS is legally invalid if the original lender goes bankrupt, which, let's be honest, happened constantly in 2008, or if the Wall Street entity currently holding the note isn't even a registered member of MERS.
Right. Furthermore, and this is really the most devastating legal argument against the system, the lectures argue MERS cannot possibly be a true beneficiary of the deed of trust. Why? Because MERS never funded the loan. MERS is just a database. They never lent you a dime, they never extended credit, they never suffered a loss.
So how can a database initiate a foreclosure on a physical piece of property?
That is the multi-trillion-dollar question, isn't it? If we connect this back to the fundamental requirements of contract law, you cannot be the beneficiary of a financial contract if you provided no consideration. Consideration is the legal term for the exchange of value. MERS provided no consideration. Therefore, their authority to act as a beneficiary and initiate foreclosure proceedings is highly susceptible to legal challenge if a borrower demands strict proof.
Wow. And the rabbit hole goes even deeper when you introduce the insurance angle. This part of the curriculum absolutely blew my mind. The lectures point out that these massive pools of mortgages, these tranches sitting in the Wall Street trusts, were heavily insured by entities like AIG. We were talking about credit default swaps and massive indemnification policies.
Let's break down how a credit default swap alters the fundamental nature of the debt. Because a credit default swap is essentially just an insurance policy on a bond or a tranche of mortgages. The investors who bought these mortgage-backed securities wanted protection, so they paid premiums to entities like AIG. The agreement was, if the homeowners in this massive pool default on their mortgages and the security loses value, AIG will pay out a massive insurance claim to make the investors whole.
And during the financial crisis, that is exactly what happened. Massive defaults triggered massive insurance payouts.
Correct. The sources suggest that when large numbers of these loans defaulted, the investors holding the tranches were fully indemnified. They were paid out by the insurance companies or, in some cases, through government bailouts.
Okay, let me walk through the logic of this because the implications are staggering. If my mortgage is chopped up, put into a trust, the trust is insured by a credit default swap, and I lose my job and default on my payments. The insurance triggers. AIG pays the trust. The investors get their money.
That is the assertion made by the analysis of these securitized trusts, yes.
So, if the investors were made whole by the insurance payout, who is the bank representing when they send a repo crew to foreclose on my physical house? The lectures argue that foreclosing after an insurance payout constitutes double dipping on the exact same debt.
This raises a profoundly important question about legal standing and the concept of a real party in interest. If the debt was fully paid off by an insurance policy, who actually owns the loss? I mean, think about it. If the trust was made whole by AIG, the trust has no injury. If the original lender sold the note years ago, they have no injury. If the servicing company just collects payments for a fee, they have no injury. The party initiating the foreclosure must have suffered an actual unreimbursed financial injury to have standing to sue you or take your property. If the ledger was balanced by an insurance payout, where is the injury? You cannot collect a debt twice.
That is wild. And to add insult to injury, the curriculum dives into how the loans were originated in the first place, focusing heavily on yield spread premiums.
Yes, they are looking at the very genesis of the contract for fatal flaws.
A yield spread premium is essentially like a legally sanctioned broker bribe. If I go to a mortgage broker and I have great credit, I might qualify for a 4% interest rate. But the bank tells a broker, hey, if you can convince him to sign a contract for a 5% interest rate, we will pay you a massive cash bonus on the back end. The broker steers me into a more expensive, riskier loan just to pocket the kickback.
And the sources classify these yield spread premiums as undisclosed finance charges. The borrower is rarely, if ever, clearly informed that they are paying a higher rate specifically to fund a kickback to their broker. The curriculum argues this is a direct violation of the Truth in Lending Act, or TILA, because it fundamentally misrepresents the true cost of the credit being extended.
It's just a layer cake of regulatory violations, broken chains of title, and hidden insurance payouts. I want to offer another analogy here because the sheer scale of this deception is kind of hard to visualize. It's like playing a game of three-card Monte on a global scale. You, the homeowner, sit at a table and sign a simple piece of paper. You think you are making a straightforward deal, but the moment you look away, Behind the scenes, the bank chops your mortgage into 1,000 tiny pieces, sells those pieces to Wall Street investors, insures those pieces against failure with AIG, gets fully paid out when the system fails, pays kickbacks to the broker who set you up. And then, after all of that convoluted financial engineering, a completely disconnected servicing company still tries to collect the whole pie from you by taking your physical house.
And that expansive three-card Monty analogy, it perfectly illustrates why William Sarton's lazy strategy of demanding strict proof of the holder in due course is so devastating to the banking institutions. Because the bank is trying to enforce a very simple binary contract on the front end. You borrowed money, you missed a payment, we take the house. But they are desperately trying to hide the labyrinth of complex, convoluted, and potentially fraudulent financial engineering on the back end.
Right.
So by demanding the unbroken chain of title, by demanding the receipts, you are forcing them to bring that entire labyrinth into the light of the courtroom. You are forcing them to explain the trust, the MERS shell game, the insurance payouts, and the broker kickbacks. They desperately want to avoid that scrutiny because the deeper you dig, the more their claim of clear legal standing just disintegrates.
Man. So if the forensic audit reveals the bank might not even hold the note, and the insurance payout means they haven't suffered a loss, that's a massive level of defense. But we are now moving into a part of the curriculum, specifically lectures 1206 and 1207, that takes this a massive radical step further. We have been operating under the assumption that the bank lent you money, even if they later sold the debt. But this section of the curriculum argues that the bank never actually lent any of its own money at all.
This is undoubtedly the most paradigm-shifting, controversial concept in the entire source material. It attacks the very genesis of the loan itself. It challenges the fundamental nature of what we even consider money.
Let's walk through the money creation sequence exactly as it's taught in these lectures, because it sounds like science fiction until you break down the mechanics of fiat currency. So it starts with the borrower. Step 1. You sit down at the closing table, and you sign your name to a promissory note for, let's say, $300,000. Step 2. You assume the bank reaches into a vault, takes out $300,000 of their own money, and gives it to the seller of the house. But the lectures state that note is not put in a vault. It is presented to the Federal Reserve window, or an entity like Fannie Mae or Freddie Mac. Step 3, and this is the absolute kicker. This presentation of your promissory note authorizes the printing of new money based entirely on the value of your signature.
Exactly, and the conclusion drawn by the source material is quite literal here. The money belongs to the borrower, not the bank. The argument is that the bank never reached into a vault of its own assets, nor did it deplete its own depositors' funds to hand you cash. Instead, the bank merely facilitated the monetization of the borrower's own credit. Your signature, representing your future labor and your promise to pay, is the actual asset that generated the value. The bank just acted as a clearinghouse to convert your signature into a digital deposit.
And to back this up, the lectures don't just rely on theory, they cite specific case law. They repeatedly reference a case called National Bank of Camden v. Good Roads Gravel Co.
Yes, and the specific legal principle extracted from that case is vital to this argument. The ruling establishes that a national bank cannot lend its credit or guarantee the obligations of another unless it owns or has a proprietary interest in the obligation.
And they pair that case law with statutory banking limits. They cite Title 12 of the United States Code, which restricts national bank lending activities.
Title 12 U.S.C. is the bedrock of federal banking regulation. The lectures point to statutes stating banks can deal in obligations for their own account up to a 10% aggregate limit of their capital and surplus, or 25% for commercial and small business mortgage securities. So the implication the curriculum draws from these specific statutory limits is that banks mathematically do not have the retained capital or surplus to actually lend their own pre-existing money to fund the millions of mortgages originated every year. The volume of lending vastly exceeds their statutory capital limits, which implies the money must be created at the point of signature rather than lent from existing reserves.
Furthermore, the curriculum asks us to look at the physical nature of the mortgage document itself. When you look at the deed of trust or the promissory note, it isn't framed as a bilateral negotiated contract between two equal parties. It's often structured as a one-signature adhesion contract, or, using older common law terminology, a covenant.
Right. The distinction between a contract and a covenant is subtle but legally significant. And the lectures point to a specific typographic detail on these documents, the word seal.
Right, I've seen this. On many legal documents, right next to the line where you sign your name, the word seal, or the letters LS, which I think stands for locus sigilli, are printed.
Precisely. In historical legal terms, signing a document under seal implies a one-sided grant of value. You aren't negotiating an exchange. You are granting something to the other party. The lectures argue that by signing this document under seal, you are making a one-sided grant of the value of your signature to the bank. The bank then takes that grant, monetizes it through the Federal Reserve System, and loans your own newly created money back to you at interest.
Okay, I have to step in and play the heavy skeptic here. Let me push back on this. Are the lectures literally saying that my blue ink pen is a magic wand? That simply by signing my name, I print cash out of thin air, and the massive brick-and-mortar bank is just a glorified middleman taking a massive cut of my own magic money? I mean, if I walk into a civil court in downtown Los Angeles, stand before a judge and say, Your Honor, I don't owe the bank a dime, they didn't lend me anything, my signature created the money, wouldn't they just last me right out of the courtroom and order the eviction immediately?
It's a highly justified skepticism, and your hypothetical is exactly what would happen. If you walk into a standard equity court and bluntly make the magic wand argument without intense procedural backing, you will almost certainly be categorized as a frivolous litigant, and you will lose your case rapidly. However, to understand the curriculum, we really have to look past the blunt phrasing and unpack why this argument exists. What fundamental legal principle is it attempting to attack?
Let's do it. Strip away the magic wand. What is the underlying legal logic here?
It is a targeted philosophical attack on the fundamental premise of consideration in contract law. We touched on this earlier. For any contract to be legally valid and enforceable, there must be a quid pro quo, an exchange of value. If I agree to buy your car, you give me the car, and I give you $10,000. That exchange is the consideration. If one side provides nothing of value, the contract is void. The curriculum is highlighting the profound difference between a historical vault banking system and our modern fractional reserve fiat currency mechanics.
Right, because in a fiat system, money isn't tied to gold. Money is created through the issuance of debt.
Exactly. When a modern bank issues a loan, they don't go down to a vault, load up a briefcase with gold bars and hand it to you. They don't even move existing money from another depositor's account into yours. Through the mechanics of double-entry bookkeeping and central banking, they create a new digital deposit on their books, and that new money is backed entirely by the promissory note you just signed. The curriculum is arguing this. If the bank risked absolutely none of its own pre-existing capital to fund your loan, if they suffered zero depletion of their own assets, then what value did they actually bring to the table? What was their consideration?
And if they provided no consideration, then legally no valid contract exists.
That is the core argument. Even if a modern judge rejects the premise because standard banking practice allows for this monetization, the underlying philosophical and legal question is profoundly serious. What exactly did the bank risk? And if they risk nothing, if they simply monetized your promise to pay, how can they claim the equitable right to take your physical house, your actual tangible property, as a penalty for a default?
It just reframes the entire power dynamic. The bank isn't the benevolent grantor of wealth. They're a toll collector on your own creditworthiness. Okay, so we have the grand theory. The bank has no standing because the chain of title is broken by securitization and clouded by insurance payouts. And at an even deeper level, the bank provided no consideration because they just monetized my signature. But as we discussed, grand theories don't stop an eviction crew from knocking on your door. How does the curriculum advise the listener to actually fight back practically? We're moving from the theoretical to the battlefield. The sources provide a highly specific, very aggressive offensive playbook.
It is a highly tactical playbook, and it starts long before you ever set foot in a courtroom. It begins entirely in the realm of administrative procedure, specifically using a preemptive strike called the notice and demand.
The sources outline a very strict six-point structure for this notice and demand document. It isn't just an angry letter to customer service. Let's walk through the mechanics of a hypothetical letter.
Gladly. If you are going to put a bank on notice and establish a legal record, the curriculum states you must strictly establish these 6 elements. Point 1, what they are doing. You must clearly state the action they are taking against you. For example, you are threatening to initiate a non-judicial foreclosure on the property located at 123 Main Street. Point 2, injury suffered. You cannot just complain, you have to articulate how their action is causing you demonstrable harm. This could be financial harm, damage to credit, emotional distress, or interference with your free will and quiet enjoyment of your property.
Point 3, duty owed. You have to state what their legal or contractual obligation is to you, like you have a duty to prove you are the lawful holder in due course before demanding payment. Then point 4, breach of duty. How exactly are they failing in that obligation? You have failed to provide the unbroken chain of assignments proving your standing.
Right. And point 5 is the value of damages. You must put a specific calculated price tag on the injury you outlined in point 2. And finally, point 6, demand for performance and consequence. You demand they correct the breach, produce the original note within 30 days, and you state exactly what will happen if they don't. Failure to produce the note will result in a default judgment against your claim.
And the sources emphasize that by sending this perfectly structured letter, you're establishing a legal concept called tacit procuration. What does that mean in plain English?
Tacit procuration is a principle deeply rooted in administrative and common law. It essentially means that silence equates to consent. By sending this formal, legally structured notice via certified mail and giving the bank a specific, reasonable window to respond, you are setting a legal trap. The banking bureaucracy is massive and slow. They frequently ignore these letters or respond with irrelevant, automated boilerplate. The curriculum argues that if they fail to respond point by point, they are tacitly agreeing to your terms. They are admitting fault through their silence or their failure to specifically rebut your claims. You are building an undeniable administrative record of their default before you ever have to file a formal lawsuit.
You are building the trap, letting them walk right into it through their own bureaucratic incompetence, and then springing it. And speaking of aggressive, unconventional tactics, we have to talk about the labor ledger. This concept absolutely blew my mind when I read the source material.
Oh, it is a fascinatingly aggressive interpretation of the standard deed of trust. It turns the bank's own boilerplate language into a weapon.
So if you read a standard deed of trust, it almost always requires the borrower to maintain the physical property, right? You have to keep the lawn mowed, fix the roof if it leaks, paint it, generally don't let it fall into disrepair. The bank requires this to protect the value of their collateral. The strategy here advises the homeowner to keep a meticulous, itemized ledger of all the labor they expend maintaining the property. Every time you mow the lawn, every time you fix a pipe, you log it.
But you aren't billing your time at minimum wage.
No. The curriculum suggests billing this labor at $250 an hour or even more based on a contractor's rate. You keep this ledger running for years, and then when the bank threatens foreclosure, you use this massive accumulated labor claim to offset the alleged debt you owe the bank.
And to jump in on the legal analysis here, this tactic is entirely about commercial leverage. The bank views the relationship as entirely one-sided. They provided the money, you owe them the money, and you must maintain the collateral for free until the debt is paid. By submitting a formalized labor ledger, you are forcefully injecting a commercial counterclaim into the relationship. You are telling the bank, if you are claiming this is your property that you are foreclosing on, then I have been acting as an unpaid private contractor maintaining your physical asset for a decade, and here's my invoice for services rendered.
It's just a total legal judo flip. Instead of fighting the bank's infinite legal budget with your limited funds, you're using the requirements of their own contract against them. I mean, charging the bank $250 an hour to mow my own lawn because their contract says I have to maintain their collateral. It is wild. It's audacious, but it creates a massive accounting nightmare for them.
But the playbook doesn't stop with creative ledgers. The sources outline an entire arsenal of what I'll call federal information weapons. Yes, using existing federal consumer protection statutes to force transparency and paralyze the foreclosure machinery. The primary weapon detailed here is RESPA, the Real Estate Settlement Procedures Act. Under RESPA, a borrower has the right to send a qualified written request, or QWR, to their mortgage servicer.
And a QWR isn't just a polite request for information that they can ignore.
No, a QWR is a powerful statutory mechanism. It legally forces the mortgage servicer to provide detailed, granular information regarding the underlying trust, the actual beneficiary of the note, and a full accounting of the loan's history. Crucially, RESPA imposes strict legal timelines on the servicer. They must acknowledge the QWR within a few days and provide a full response within a set period. If they fail to comply with these strict timelines, that failure creates statutory damages and provides significant legal leverage to halt a foreclosure.
The sources also suggest weaponizing FOIA, the Freedom of Information Act. Now, normally FOIA applies to government agencies. I can FOIA the FBI or the EPA. But the argument here is that because these massive banking institutions are so deeply intertwined with the Federal Reserve and government-sponsored entities like Fannie Mae and Freddie Mac, they are essentially acting as quasi-federal agencies.
The theory is that if a private bank is utilizing the Federal Reserve discount window to monetize your signature, they are operating under the color of federal authority, and therefore can be compelled to produce internal information under FOIA, just like an agency would. It is a controversial interpretation, but it adds another layer of administrative burden to the bank.
And we return to TILA, the Truth in Lending Act. The curriculum highlights TILA's standard 3-day rescission window, which normally allows a borrower to cancel a loan within 3 days of signing. But they tie this federal statute to state civil codes, specifically citing California Civil Codes 1689 and 1691, arguing that if fraud was involved in the origination of the loan, like those undisclosed yield spread premium kickbacks we discussed, the contract is subject to rescission long after those 3 days. They argue fraud vitiates the contract entirely, meaning you can demand rescission years later.
It is a multifaceted attack. You demand proof through administrative notice, you create a massive counterclaim through the labor ledger, and you weaponize federal statutes to demand transparency they cannot provide.
Okay, so you've run the administrative gauntlet, you've sent the notices, billed them for mowing the lawn, hit them with Reese PN FOIA. But what if the bank just ignores it all and schedules the house to be sold at auction anyway? The curriculum has a specific plan for clouding the title to stop an auction in its tracks.
Clouding the title is arguably the most effective practical way to paralyze a property's marketability. The entire real estate system relies on clear title. If a title is clouded, a title insurance company will refuse to insure it. And if there is no title insurance, no secondary bank will finance a buyer to purchase the property at auction. The asset becomes frozen.
It's like throwing a massive, sticky spider web over the property record. How do we actually do that? The sources extensively detail the use of a lis pendens.
A lis pendens is a formal statutory notice filed directly with the county recorder's office. It puts the public on notice that the title to this specific property is the subject of ongoing litigation. However, the lectures note a significant practical hurdle. In many jurisdictions, including places like California, county recorders have become hostile to pro se litigants, people representing themselves. They may actively refuse to accept a lis pendens for recording unless it is signed and filed by a licensed attorney.
Which is a massive problem if your entire philosophy is acting as your own sovereign representative against the system. If the clerk won't take your paper, the strategy dies.
Exactly. So the curriculum offers a brilliant common law workaround, the preservation of interest. They describe this document as the codified common law equivalent to a statutory lis pendens. Because it is rooted in common law rights rather than a specific court statute, a clerk has far less authority to refuse recording it. Anyone can file it. Once it is stamped and on the public record, it serves the exact same function. It warns any potential buyers, investors, or title companies of a severe dispute, and it effectively trashes the property's immediate commercial viability.
They also mention filing UCC-1 financing statements. The idea here is to legally secure your own debt, like that massive labor ledger you've been keeping for years against the property itself. You're placing a lien on the house for your unpaid contracting work, creating yet another massive financial hurdle for any bank trying to sell it out from under you.
The overarching goal of all these title clouding tactics is friction. You want to make the property so legally toxic, so entangled in competing claims and liens, that the bank simply cannot quickly dispose of it at a foreclosure mill auction. You are forcing them to actually stop, look at the file, and address your underlying arguments about their lack of standing.
Which brings us to the final and perhaps most confrontational practical tactic outlined in the playbook: targeting the sheriff. Let's say the bank pushes through, the unlawful detainer is finalized by a judge, and an eviction order is issued. It's the local sheriff's department or the local marshals who actually show up at the door with guns and badges to physically enforce that eviction. How does the curriculum advise handling law enforcement?
It relies entirely on a deep understanding of liability, specifically shifting personal liability onto the individual officers. The standard operating procedure for a sheriff is to assume a court order is valid and execute it. They have sovereign immunity while acting within the scope of their official duties. The strategy here is to shatter that presumption. The curriculum advises notifying the sheriff in writing, usually via certified mail, specifically 7 days in advance of any scheduled action.
And what does that notice say? Are you threatening to physically resist the sheriff?
No, absolutely never. Physical resistance is a guaranteed way to lose everything and end up in jail. The notice is a legal warning. You are officially informing the sheriff, with attached documentation, that the court orders they are being asked to enforce are legally invalid, void on their face, usually due to the severe jurisdictional and standing issues we've discussed, the lack of a holder in due course, the fraud of securitization.
You are putting them on notice that the paperwork they are holding is a lie.
Precisely. The legal mechanism here is that if a law enforcement officer knowingly executes a void order, or acts outside their lawful jurisdiction, they are no longer operating under the protective umbrella of the state. They lose their sovereign immunity. The curriculum states this goal explicitly. You want to induce a profound fear of personal financial liability in the individual officer or the sheriff themselves. You're making them realize that if they enforce this fraudulent bank eviction, they could be held personally liable for civil rights violations.
You want them to fear the loss of their own house, their own job, or their own pension if they blindly follow the bank's paperwork.
It is a profound application of psychological and legal pressure. You are moving the dispute from an abstract paperwork battle against a faceless, multi-billion-dollar corporation to a very high-stakes, intensely personal standoff with the specific human beings tasked with enforcing the corporation's will. Their own risk management instincts should cause them to pause, consult their county counsel, and refuse to enforce the eviction until the legal mess is sorted out.
Okay, so we've run the entire administrative gauntlet. We've shifted the burden of proof, clouded the title, billed for our labor, and warned the sheriff about personal liability. But what if all of that friction still doesn't force the bank to offer a settlement? What if they call your bluff and you have to fight this out in front of a judge? This takes us into the final section of our deep dive. We are looking at courtroom procedure and the ultimate philosophical endgame regarding true property ownership, drawing from lectures 1206, 1207, and specifically the property theory in lecture 1301.
When you cross the threshold into a courtroom, the curriculum outlines very specific procedural maneuvers designed to keep the bank off balance. One of the most prominent tactics they teach is the aggressive use of the ex parte motion.
Ex parte. I know from watching legal dramas that usually means a meeting or a motion made without the other party present.
Correct. In standard litigation, you file a motion, serve the other side, and wait weeks or months for a hearing where both sides argue. In an ex parte motion, the plaintiff approaches the court unilaterally, usually claiming an urgent, immediate need for relief, like stopping an imminent auction. The strategic goal here isn't necessarily to get a final secret ruling from the judge right then and there. The goal is to secure an order to show cause.
Let's break that down. What does an order to show cause actually do to the momentum of the case?
It completely flips the procedural momentum. If the judge reads your ex parte motion detailing the massive fraud of securitization and grants it, they issue an order to show cause. This is a legal mandate that forces the bank's attorneys to come to court on a specific date and justify their actions. They must literally show cause why they shouldn't be stopped from foreclosing. Instead of you constantly fighting to be heard and struggling to push the case forward, the bank is now under a direct court order to explain themselves and defend their paperwork. It puts them on the defensive immediately.
And when you are actually drafting the lawsuit, when you are listing out your claims against the bank, what is the actual cause of action? What are you legally suing them for? The lectures place heavy emphasis on a specific common law claim called trespass on the case.
To understand why they use this, we have to make a distinction between two ancient common law concepts. Standard trespass, which most people are familiar with, involves a direct injury accompanied by force or the threat of force. If someone kicks down your front door or physically drives a tractor onto your land, that is standard trespass.
But the bank isn't breaking your door down with an axe.
Exactly. So the curriculum uses trespass on the case, often just referred to historically as case. This cause of action involves an injury that occurs without direct physical force. It encompasses injuries resulting from fraud, deception, negligence, and breach of duty. The curriculum identifies this as the perfect primary vehicle for mortgage disputes because the injury isn't physical. The injury is perpetrated through fraudulent paperwork, hidden kickbacks, and deceptive securitization practices.
And the lectures advise that when you file this action, you don't just speak in dry, abstract legal theory. You narrate the full, comprehensive story of the predatory lending process. You detail the specific dollar amounts of the yield-spread premiums, you chart the interest rate explosions of the adjustable rate mortgage, you list every undisclosed fee. You use the lawsuit to paint a vivid picture of systemic fraud.
You are forcing the court to look at the entire arc of the deception, not just the single missed payment that the bank wants to focus on.
Now, to fully grasp the absolute endgame of this entire curriculum, we have to look closely at Lecture 1301. This is where the strategy moves beyond just beating the bank in court and enters into a deep dive into historical property theory. Specifically, they focus on the fundamental battle between lemon theory and title theory.
This distinction is fundamental to understanding American property law and how the curriculum plans to defeat it. The sources cite a pivotal Supreme Court case. United States v. Certain Interest in Property in Champaign County. This case established clear precedent for how property is viewed in states like Illinois, which operates under lien theory.
And the ruling in that case was that in a lien theory state, the mortgagee, meaning the bank that issued the loan, only possesses a lien on the property to secure the debt. They do not have a vested interest or actual ownership in the property itself.
That is a crucial limitation of bank power. A lien is just an equitable claim. It is not ownership. Contrast this with a title theory state, where the legal fiction is that the bank actually holds legal title to the property until the loan is fully paid off. But the curriculum notes that even in title theory states, modern courts of equity have heavily diluted the bank's power, often treating them more like lien holders anyway. But the curriculum only uses this discussion of liens and titles as a stepping stone. They use it to pivot to an even higher, almost mythological concept of ownership.
Right, because the ultimate goal of these lectures isn't just to beat the bank's lien and keep a standard deed. The ultimate goal is to secure something called a allodial title.
To truly understand allodial title, we have to travel back to the English common law system, specifically looking at the aftermath of the Norman Conquest in 1066. In feudal England, only the king held true allodial title, meaning absolute, sovereign ownership of the land, free and clear of any duties to a higher power. Everyone else in the kingdom, even the highest nobles, held what is called a fee simple estate. Fee simple meant you had the right to use the land, live on it, and pass it to your heirs, but you still fundamentally owed duties, taxes, or military services to a higher lord, and ultimately to the king. The king was the true owner.
Most homeowners today have a fee simple deed. You think you own it, but if you don't pay your property taxes, the state takes it away, proving you don't have absolute ownership.
Yeah,
But the Leckers argue that the Founding Fathers chose a radically different path for the United States.
they did. The curriculum argues that the American Revolution fundamentally altered this feudal hierarchy. They cite early foundational cases like Chisholm v. Georgia, asserting a profound philosophical shift. The absolute sovereignty that was previously held by the king transferred directly to the individual people of the newly formed states. The logical conclusion drawn by the lectures is this. If the individual people are now the true sovereigns, they have the right to hold land exactly as the king did, allodially. Absolute ownership, free of any superior landlord, free of state taxation, and certainly free of commercial bank land.
And how does a modern American citizen actually secure this allodial title? According to the curriculum, it requires digging up or securing a land patent.
A land patent is the original supreme document of land transfer, historically issued by the federal government, often through the Bureau of Land Management. It is the original grant of public land to a private individual. The lectures present the land patent as the highest possible form of title on earth. It is the absolute apex of property ownership.
And crucially, the sources claim that once you bring a land patent forward in your name, it is completely immune from collateral attack in a state equity court, even if there are allegations of fraud on your modern mortgage. They argue that securing a land patent places the sovereign freeholder completely above the reach of commercial bank foreclosures. Okay, I have to jump in here and push back on this entirely because this sounds too good to be true. So if I manage to dig up the original 1800s land patent from the Bureau of Land Management for my specific plot of land, and I somehow attach my name to it, I suddenly hold this medieval-style allodial title. I become an untouchable sovereign king of my suburban quarter acre, and it makes me completely immune to the bank I just signed a 30-year commercial contract with. That sounds like a literal legal cheat code. If this is true, why isn't absolutely everyone doing this? Why are people getting foreclosed on at all?
It is the most critical question you could ask, and answering it requires us to provide the vital context that separates common law theory from modern courtroom reality. The curriculum is drawing on a very deep, historically accurate common law concepts: the transfer of sovereignty after the Revolution, the supreme nature of original federal patents, and they are attempting to aggressively apply them to nullify modern commercial contracts. The massive gap, however, is that modern courts, specifically courts of equity, operate almost entirely on statutory law, commercial codes, and thousands of pages of modern banking regulations. They do not operate on 18th century land patent theory. When you sit down and sign a modern deed of trust, you are voluntarily entering into a commercial agreement governed by those modern codes. The curriculum's argument is that your fundamental sovereign allodial right to the land supersedes any commercial contract you might have signed.
They're basically saying the ancient common law is the higher law, and the modern commercial contract is an inferior, almost irrelevant legal fiction.
Yes. They interpret the American Revolution as a literal transfer of the king's absolute, unassailable sovereignty directly to the individual. This forms the philosophical bedrock of their entire system. If you are a sovereign and you hold a supreme land patent, a mere commercial bank holding an equitable lien cannot possibly dispossess you of your sovereign territory. Why isn't everyone doing it? Because executing this strategy is not a cheat code. It is a declaration of absolute legal war against the prevailing momentum of the entire modern financial and judicial system. It requires acting as your own attorney, filing immensely complex common law actions, enduring years of litigation, and facing judges who are trained exclusively in the very statutory, equity-based system you are actively attempting to dismantle and delegitimize. The friction is immense, and the system aggressively protects itself against these arguments.
Which brings us to the perfect place to wrap up this analysis. Let's bring it all together. Remind yourself, as you're listening to this deep dive, that what we've explored today is absolutely not standard legal advice. You shouldn't go start billing your local bank $250 an hour for mowing your lawn tomorrow morning just because you heard it here.
I strongly agree. Attempting these strategies without a profound understanding of the risks is dangerous.
What this curriculum provides, however, is a fascinating, radical, and eye-opening alternate lens through which to view the contracts we sign every single day. Whether it's the startling realization that your own signature might actually be the mechanism generating the value of your loan, or simply gaining a deeper, more cynical understanding of the chaotic, opaque paper trail of mortgage securitization and MERS, you now possess a deeper awareness. You understand the invisible architecture of your mortgage.
You've seen the vulnerabilities and the armor of the financial giants. You understand that the entire system relies heavily on your silent consent and your absolute presumption that their paperwork is flawless. And as we've seen, that paperwork is rarely flawless.
So we want to leave you with this final provocative thought to mull over. If the core theory from these lectures is true, if massive banks rely entirely on the borrower's signature to generate the value of the loan, and they risk virtually no actual capital of their own in the process, what does that say about the entire global debt economy? If tomorrow, every single borrower in the country suddenly adopted William Sarton's philosophy of laziness, if millions of people simultaneously demanded strict proof of an unbroken holder and due course chain, if everyone started submitting massive labor ledgers for property maintenance, would the global financial system collapse under the sheer weight of its own unprovable paperwork? Or would it just be forced finally to show its hand and admit how the game of debt is actually played? Thank you for joining us on this deep dive into the source material. We'll see you next time.